is Maurice Couchman.
This case opens with a deceptively routine tone, but beneath it sits a classic example of how quickly emotions can spiral into criminal liability. What we're about to witness isn't a violent outburst in a physical sense. It's something far more common in modern courts. Digital harassment escalating into a stalking charge. And that's important, because many people underestimate how serious repeated communication can become under the law. Here, the courtroom is setting the stage for a plea hearing, which means the defendant is not fighting the charge. He's accepting responsibility. That immediately shifts the focus from "did it happen" to "what are the consequences" and "how severe was the behavior." Pay attention to how the judge handles this. And as judges in these situations are not just confirming guilt, they're ensuring the defendant fully understands the weight of what they are admitting to. Because once that plea is entered, there's no going back. And here's the bigger question for you. When does persistent texting cross the line from emotional reaction into criminal conduct? Is it intent, volume, or the victim's response that matters most? This case is about to answer that in a very direct way, and it may not be what most people expect.
And good afternoon, Your Honor. Brendan Dabalski appearing on behalf of Maurice Couchman. Mr. Couchman, please state your name for the record, sir.
Maurice Orlando Couchman.
All right, thank you. What are we doing?
Your Honor, today's date and time set for a pretrial on this matter. Last time we were before Your Honor, the prosecution offered a prosecution deferral on this matter, and I needed some time to discuss this matter with my client. After discussing it with him, he'd like to move forward and accept that.
So he's going to plead to this charge with the prosecutor's deferred?
That is correct, Your Honor.
And that's correct, Your Honor.
All right, thank you. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record.
Maurice Orlando Couchman.
Mr. Couchman, it is this court's understanding that you're going to be pleading guilty to the charge of stalking.
Yes.
That is a misdemeanor. It is punishable by up to 1 year incarceration, a $1,000 fine plus court costs, and up to 5 years of probation. You understand that, sir?
Yes, Your Honor.
This is where the legal reality hits hard. A misdemeanor stalking charge might sound minor at first, but listen closely to the penalties. Up to 1 year in jail, fines, and potentially 5 years of probation. That's not a slap on the wrist. That's a long-term impact on someone's life. The judge is doing something critical here, ensuring the plea is knowing and voluntary. In legal terms, that means the defendant fully understands the consequences before admitting guilt. If that step is skipped or mishandled, the entire plea could be challenged later. Now, notice how calm and direct the defendant is in accepting this. There's no hesitation, no confusion, which suggests this decision was likely discussed in detail with his attorney beforehand. But here's where it gets interesting. Stalking laws don't require physical harm. Repeated unwanted communication alone can meet the threshold if it causes fear or distress. That's a major shift in how the legal system treats harassment in the digital age. Ask yourself this: should sending messages, even hundreds of them, carry the same weight as physical intimidation? Or is the psychological impact just as serious? The court clearly leans toward the latter, and that's about to become even more evident.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
I plead guilty.
December 1st, 2023, at the location of 3001 Washington County, State of Michigan. What did you do involving an illicit Chamberlain that makes you think that you're guilty?
Honestly, Your Honor, I let my emotions get the best of me. I sent her a bunch of text messages, and I'm just trying to get this all put behind me.
So on that day, you sent her a bunch of text messages. How much are a bunch of text messages?
I have no idea. Probably a lot, maybe over 100.
You sent her 100 text messages?
Probably something like that.
And that was in one day?
Yes, Your Honor.
And would you agree that did she tell you to stop doing that?
Yes, Your Honor.
And you continued?
Yes, Your Honor. Like I
And
said,
you would agree that your behavior would have been a harassment toward her
yes, Your Honor.
and would potentially make her feel terrorized by your conduct?
Yes, Your Honor.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
June 3rd at 1 p.m.
June 3rd.
Thank you, Your Honor.
With that statement, the case shifts from accusation to consequence. The plea is officially accepted, and now the focus moves to sentencing. But before that happens, the court orders a pre-sentence investigation, often called a PSI. This step is critical. It's where probation officers evaluate the defendant's background, behavior, and risk level. They'll look at factors like prior history, personal circumstances, and the nature of the offense to recommend an appropriate sentence. In other words, the judge isn't making a final decision yet. They're gathering more information to ensure the punishment fits both the crime and the individual. This also signals something else. The court sees this case as serious enough to warrant deeper review, rather than issuing an immediate sentence. And here's the key takeaway. Once a guilty plea is entered, the defendant's control over the outcome is limited. The narrative now belongs to the court system. Would you have taken the plea in this situation, knowing the potential consequences, or would you have risked going to trial? That decision alone can completely change the trajectory of a case, and for Couchman, that choice has already been made.
Bond with its conditions will continue. Thank you.
Your Honor, will the court reach, or will the probation department reach out to Mr. Couchman, or should he be proactive and reach out to them?
He should call our probation office.
Okay, thank you.
Thank you.
Have a good day.
Good afternoon,
Okay.
Assistant Public Defender Lauren Perny on behalf of Ms. Naveen. Please state your name for the record.
Alexis and Alexander Naveen.
We're here for a pretrial and a bond violation. We're ready to resolve the bond violation. She will admit to the allegations of contact and would like to provide the court some context if you would allow that.
Go ahead.
Your
Alex.
Honor, I do admit I was wrong. Let me start there. I was wrong.
Now we transition into a different defendant, and immediately, the tone changes. Instead of a structured admission, we're hearing a personal explanation, almost a narrative. This defendant isn't just admitting guilt, she's trying to contextualize it. She's explaining confusion about living arrangements, the marriage license, and the emotional shock of seeing her child. And this is where courtroom strategy becomes visible. Her attorney allows her to speak, which can humanize the defendant, but it also opens the door to scrutiny, because every explanation can be interpreted as either accountability or excuse. Notice how she repeatedly says, "I was wrong." That's important. Judges look for acknowledgement of responsibility, but they also listen for consistency. The complication here is the bond violation. Unlike the previous case, this isn't just about what happened, it's about disobeying a direct court order. And courts take that very seriously. Here's the question. Does emotional distress justify breaking a court order, or should the law remain rigid regardless of personal circumstances? Because in this moment, the judge is weighing not just what she did, but whether she can be trusted to follow rules moving forward.
When I got out, I thought that she was going to be at her mother's house. And when we went to arraignment, they said she's going to be at her mother's house and I could return to my home. But I didn't know until the end, when they were releasing me, that I could not return to my home. So that was a surprise. And I called the police like I was told to do. She packed up some of my stuff. She left our marriage license on the front of my driver's side. I didn't know we were married, Your Honor, because we had gotten married a couple of weeks before and we had talked about not filing the marriage license. And so she filed the marriage license after the incident. And I did not know that we were married until she left it on the seat. And so when I did call, she had packed it up. She'd packed up my stuff. I did leave, but then I realized she didn't give me shoes. And so I called the police officers back. I was away from the house. I was down the street. I was trying to do the right thing. They got called an emergency, so I was waiting longer, and I saw my son get out of the car, and I saw her pull the trash cans up. I did not approach them. I did not try to approach them. But when I saw my son, that's what broke me, is I saw my son. And so I did violate, Your Honor, I did violate, but I was not aggressive. I did not approach them. I did not come near them. I did send text messages, but I didn't understand with the marriage license and it broke me. My son broke me. That's why. And I wanted to know if there was hope. That's all. And I do acknowledge I was wrong. I do learn, and I will not contact her again. 100%.
I will add, Your Honor, she has been in custody for about 5 days, I believe. If she were to be released, she would be staying at a hotel nearby. The house was recently flooded, so she actually has funds from the VA to stay somewhere else. There's work being done on the house. So given her admission and her owning up the fact that she did violate the court's orders, I'd ask that you sentence her to those 5 days.
What are we doing on the pretrial?
We're asking for an adjournment
Right.
on the pretrial.
Do people have something to say in this?
Yes, Your Honor, we would object to that. Given the nature of these texts and the fact that they were sent, she was, I believe, arraigned on the 22nd, sent these immediately after getting out and being told not to have contact. And in those messages, directly acknowledges that she was not to be having contact, continuously telling the victim not to contact police, and then sending other manipulative messages to the victim, intending to make her feel bad for contacting the police or trying to contact police.
This is where the prosecution pushes back, and it's a strong push. They're not just arguing that a violation occurred, they're framing the behavior as deliberate and manipulative. That distinction matters. If the court believes the defendant knowingly ignored the no-contact order and attempted to influence the victim, the situation becomes far more serious. Listen to the language. Acknowledges that she not to be having contact, and continuously telling the victim not to contact police. That paints a picture of awareness and intent, which undermines the defense's argument of confusion or emotional distress. This is a classic courtroom clash. Mitigation versus aggravation. The defense is saying she was overwhelmed. The prosecution is saying she knew exactly what she was doing. And the judge now has to decide which version is more credible. What do you think? Does her explanation hold up, or do the prosecution's claims suggest something more calculated? Because in cases involving court orders, credibility is everything. Once that's questioned, the outcome often becomes much harsher.
When's my next day?
May 13th.
May 13th.
Yes.
I'll adjourn the pretrial in this matter to May 13th. At that time, I'll also sentence her on the bond violations on that May 13th, and then her bond at this time, given what I've seen here, her bond will continue as revoked.
Yes, Your Honor.
Thank you.
Court calls the case, People versus Orville Howard.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Howard. Mr. Howard, please state your name for the record.
Orville Howard. Thank you.
Teresa Clare on behalf of probation. Your Honor, Mr. Howard is before the court for a violation of probation hearing. Mr. Howard was sentenced in this case in August of 2020. He's then on bench warrant status. The end of his probation term was in September of 22. He still has an outstanding balance of $1,097. His last payment made to the court was on March 8th of 2022. Part of that owing balance, he does have restitution, $467. He did not complete the theft class. he failed to report to probation as directed. He was before this court, or scheduled before this court, on 3 prior BOPs, one in June of 2021, one in March of 2022, where we had given him another chance to get things done, and again on March of 2023. He also had a criminal case of reckless driving out of the 1482 District Court. That alleged date of offense is March 20 of 2021. That last I saw was on bench warrant status. I'm not sure why, because he is in custody. Given all the prior attempts to get Mr. Howard to complete the terms of his probation, at this time, probation is recommending 93 days in jail, credit for 8 days served, to serve the balance, waive remaining terms, accept the financial obligations, and discharge him from probation without improvement.
I did speak with Mr. Howard yesterday in the jail. We did discuss the violation of probation. As for explanation of why he did not complete these things, Mr. Howard has been homeless, I guess, since the last VOP. He was evicted from his home. He and his family were living in a motel, his fiance and 3 children. He also has a child on the way that's due in December. He's just now getting back on his feet. He was able to secure housing through Hawk. He's also been utilizing their social services through SOS. He even told me he just recently got a cell phone, and the family got new numbers because they've been struggling so hard. He's also looking at getting back to work after finding housing and stabilizing that area of his life at a plant for Frasia? Farsia.
SOS is helping me get some security.
Okay. He did indicate SOS is attempting to help get him Social Security as well. This is a non-violent crime. There is restitution that Mr. Howard said he is going to pay once he gets back to work. I'd ask the court to discharge him from probation, instruct him to pay that money that's owing, and let him keep working on getting stabilized, he and his family.
Mr. Howard, anything you want to say, sir?
Yes, Your Honor. I just want to say that it's been a really rough, hard time. Me and my family has been homeless. We've been in and out of motels. Even myself, I've had to sleep in the woods myself to make sure my family was good. We're SOS, they were in an Alpha house, and there wasn't enough room for me. So I had to do what I had to do, was sleep out there where they were, safe to where they were. But it's been a long, rough journey. We finally are getting back on track. We finally got housed at Village Grove Apartments. Everything is starting to go up and move forward. I'm trying to get my license back. Everything is just starting to go on now. And I'm just asking for a little bit of lenience so this can keep going forward and I can do the right thing. And I will pay everything that I owe.
Okay, and I appreciate everything that's been said, but throughout this thing since 2020, I kept giving you a chance to just get things right. I get people running into difficulties. If at any point you had let probation know the difficulties, then we would have probably done something else or tried to do that, tried to work with you on this. But now we come down to here. How'd you end up in custody?
This is one of the most revealing moments in the entire hearing. The judge isn't just delivering a decision, he's expressing frustration, and that tells you everything about how this case is being viewed. Mr. Howard's situation is undeniably difficult. Homelessness, family struggles, instability, those are real challenges. But from the court's perspective, the issue isn't just hardship, it's lack of communication. The judge makes it clear, if the defendant had simply stayed in contact with probation, the outcome could have been different. That's a recurring theme in probation cases. Courts are often willing to work with people, but only if they stay engaged. Instead, the pattern here is missed opportunities, repeated chances, and ultimately non-compliance. And when the judge says, had you not been picked up, you wouldn't be here now. That's a direct hit on credibility, It suggests the court believes compliance only happened because of enforcement, not responsibility. So here's the question. Should life circumstances outweigh repeated non-compliance? Or does the system have to draw a hard line at some point? Because right now, that line is being drawn.
I was with a friend that got pulled over. He had like,
That's what I'm saying. You've got time to do that, but you don't have time to just come down.
it was actually work. I was actually working. So that's,
Okay, that's fine. I'm just saying you had time to do that, and all it was going to take was for you just to stop into probation at any given point in time.
I was trying everything I could. We didn't have phones. We lost our phones. I tried everything I could to do. I have babies. I got a
Mr. Howard, if you took the same time or even a lot less time that it took for you to contact Hawk and SOS to just let probation know what was going on with you, this goes differently.
I understand that, yeah. Is there any way that I could be placed on maybe a tether till I can get everything paid off or something other route?
I'm out of time.
So I could be with my kids and my family?
I'm out of time. I tried to work. I tried, Mr. Howard. I tried to.
Chance.
Mr. Howard, I've given you 2. I've tried it, and then you disappear. If at any point you had stepped in here, and anybody knows how I work, if at any point you had stepped in here and said, "Here's where I am, Judge," even if you don't go to probation, and just say, "Here's where I am. Can I get another shot to do this?" I probably don't have a problem with that. But you did none of that. And quite frankly, had you not been stopped and picked up, you wouldn't be here now, even.
I know that. Yeah.
Sentence of the court, 93 days in jail, give him credit for 8 to serve. Defendant is to serve the balance. I'll waive all other remaining terms except his financial obligations, discharge him from probation. Thank you.
And there it is, the final outcome. 93 days in jail, with credit for time served and discharge from probation afterward. This is a mixed result. On one hand, the defendant is serving time, which reflects the seriousness of repeated violations. On the other hand, the judge is clearing remaining probation terms, effectively closing the case after the sentence is served. That decision tells you something important. The court has lost confidence in long-term compliance. Instead of continuing supervision, they're opting for a clean break after incarceration. Across all 3 cases we've seen today, a pattern emerges. The court is consistent on one principle: accountability. Whether it's excessive communication, violating a no-contact order, or failing probation requirements, the response is the same. Actions have consequences, and regardless of intent or circumstances, but the real takeaway goes deeper. The legal system doesn't just punish behavior, it evaluates patterns. Repetition, awareness, and compliance all shape the outcome. So now it's your turn. Who do you think received the fairest outcome here? And which case stood out the most to you? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.